5 seconds to go. Start. Learned Counsel further urged that though a ground was taken in the writ petition that the Act of 1948 is not applicable to the respondent Nagar Nigam because the workshop of the respondent Nagar Nigam is not covered under the definition of factory, but the fact remains that in the proceedings for recovery of contribution, no such plea was taken that the workshop of the respondent Nagar Nigam is not covered by the definition of factory or that no manufacturing process is carried out in the workshop. He urged that the recovery certificate dated 22nd July 1976 issued by the officials of the Appellant Corporation demanding the contribution for period from 11 December 1973 to 22nd July 1976 was satisfied by the respondent Nagar Nigam, which voluntarily deposited the contributions with the Appellant Corporation for this period. However, compliance was stopped by the respondent Nagar Nigam after the year 1978 without intimation to the Appellant Corporation. Learned Counsel further urged that even otherwise, if at all the respondent Nagar Nigam was desirous of contesting the recovery notice on the ground that it was not covered under the provisions of the Act, the remedy of filing an appeal to the Employees Insurance Court, hereinafter being referred to as Insurance Court, under Section 75 of the Act of 1948 was available to it. Rather than availing the said statutory remedy, the respondent invoked the writ jurisdiction of the High Court without any justification. He thus implored the court to accept the appeal and set aside the impugned order of the High Court. Per contra, learned counsel appearing for the respondent erstwhile Nagar Nigam and presently the Municipal Corporation Allahabad urged that there is no material on record to show that any manufacturing activity was being undertaken in the workshop of the respondent Nagar Nigam. The employees of the respondent Nagar Nigam who were already being provided all possible amenities and facilities including the medical assistance etc., were being occasionally assigned the task of in-house repairs of the equipment and machinery of the respondent Nagar Nigam, and thus by no stretch of imagination can it be concluded that the workshop was a factory within the meaning of the Act of 1948 where any manufacturing process was being undertaken. He thus urged that the learned single judge of the High Court was justified in exercising the writ jurisdiction and quashing the impugned recovery notice dated 3rd February 2009, which was ex facie unsustainable in the eyes of law. He contended that the impugned order does not suffer from any infirmity warranting interference of this court and the appeal should be dismissed. We have given our thoughtful consideration to the submissions advanced at bar and have gone through the material available on record. The core issues presented for consideration of this court in this appeal are whether the workshop of respondent Nagar Nigam was indulged in manufacturing process while carrying out repairs and maintenance of the tractors, trailers, loaders belonging to the respondent Nagar Nigam by employing more than 20 workmen, whether the workshop of respondent Nagar Nigam was covered under the definition of factory within the meaning of Act of 1948. The issue whether the workshop of the municipality, local body where the job of repairs of the machinery etc. are carried out is a factory within the meaning of the Act of 1948 was examined in extenso by this court in the case of Kakinada Municipality Supra. Stop.